Hi everyone, thanks for having me here. So, unlike the previous two speakers, I'm not a doctor. I'm actually a lawyer, and our firm primarily does medical legal work. Um, but we do primarily defense work. So, that is to say, we defend doctors at hospitals, and I know there are a lot of healthcare personnel here, so that is to say, I'm not the enemy. Yeah? Okay, so broadly speaking, my talk we will cover two main issues, which is end of life care and resuscitation and how it may impact community first responders and bystanders. So my talk in general focus on these two groups of people. This first topic really I'm continuing on from Dr. Chan's talk because she touched on it briefly, but I'll go a bit more into the legal side of things. And the second part of the talk is really about bystanders, PR, and being what we call a good Samaritan. And I think there has been some fear or some concerns regarding what kind of liability that attracts, if you were to help somebody as a sort of like a random bystander. Lah. So just moving straight on to our first topic. Okay, so I think just now Dr. Chan went through the four sort of acronyms. So we have Advanced Medical Directive, which is AMD. There was LPA, DNR, ACP, very Singaporean, lots of acronyms. But I'm focusing more on the AMD and LPA side of things because these are actually legal sort of instruments as opposed to medical, right? I think Dr. Chan also mentioned about how we watch a lot of TV shows like Grey's Anatomy and House. And I think that also has sort of added into the fact that you watch these shows and then there will always be this episode, right? Where some person comes in and then they need to be saved or resuscitated and somebody will like, no, cannot. They have a DIR, don't resuscitate. And then there will be this ethical dilemma for the doctors. So what is actually a DNR, what is the and then from the TV show, it seems to appear that, oh, is it a legal document that says I don't want to be resuscitated? Does that apply in Singapore? Do we even have that in Singapore? And the short answer is kind of in a very limited sense, but also not really. Sorry for the very irritating lawyer answer. But hopefully after I go through it, you will have a better idea of what exactly this is. Okay. So Advanced Medical Directive, so AMD, really, this is involving a statutory regime for individuals to refuse extraordinary life-saving treatment when terminally ill. So all the bold things, things take note of. So it allows people who are at least 21 years old, not mentally disordered, to make a formal advance directive, right? And this is actually a legal document you sign in advance to inform your doctors who presumably be treating you in the future that in the event you become terminally ill and unconscious, that you don't want any extraordinary life-saving treatment to be used to prolong your life. Now, this regime is very highly regulated and requires actually a lot of hoops to jump through. Okay, there's a very formal registration process. There has to be certification of terminal illness, and then the action by a medical practitioner. So there's actually a lot. I'll take you through it, but it's not necessarily something that you have to really remember. But it just goes to show how limited and how regulated this regime is. So starting off is it must be in a prescribed form, right? So you see all these things, there's all these different criteria you have to go through. You have to be adult age, you have to have capacity, and then you have to have all these other criteria regarding your witness. One of them has to be a doctor, they have to do all these things. So, for instance, the medical witness must certify that the individual is not being forced to, they are not mentally disordered, they understand the nature and implications of making an AMD. After you do all that, putting in the prescribed form, having it witnessed properly, then you still need to register it with this registrar of advanced medical directives. And then one more level after that, then you still need to certify that what you have is a terminal illness. So this entire AMD only even applies if you have a terminal illness, and that terminal illness has to be certified by a medical practitioner. And again, you can see there's all these different scenarios where you have to determine things in prescribed form, forward the certificate, etc. And then at the end, when the time for the AMD is to invoke, then again, you just have to go through all these things. Then the request has to be submitted to the registrar and confirm that the individual is indeed terminally ill. So all this is to say, I know I've gone through it quite quickly, but it's not that important because I just wanted to show you how extremely limited and regulated this entire process is. And it's really only applicable in very specific situations. And it's really more relevant to sort of ongoing long-term healthcare professionals within an institution who is sort of like taking care of a terminally ill patient in the long term. Okay, so as far as it is concerns first responders or community first responders, right? There is really no requirement for them to like find out, oh, is there this AMD or not? Do they have all these? Are they terminally ill? Because if you saw how difficult and how complicated the process is, it is really not practical for a first responder to have to figure out all those things, right? And so there is also no sort of legal requirement that the law requires you must certify things. So you want to always err on the side of saving life, which is also what Dr. Chan had mentioned. Okay, so that is the AMD. So now you know that it is, not really relevant for the purposes of community first responders. Now, I also want to briefly touch upon what we mentioned just now, which is LPA, which is lasting power of attorney. So what is that? So we have this thing called appointed decision makers. Generally speaking, if a person has capacity and is of age, the person who makes the decision is the person for themselves. But in situations where they are no longer able to make decisions for themselves, there are mechanisms to provide for alternative decision maker. So there's two of them, right? The first one is an LPA. The LPA itself is a legal instrument that allows someone to designate a donee or donees to make certain decisions on his or her behalf when he or she loses mental capacity. So this is basically when you still have capacity and you want to appoint and prepare for the future, okay? And then court-appointed deputy is a person appointed by a court to make specific decisions on an incapacitated person's behalf. So this is sort of after the event. So a deputy is when, unfortunately or whatever, you didn't do LPK before you lost capacity, and you still lose capacity, and then your family members or your loved ones go through this process with the court to get appointed and get the court to grant them this power to make decisions on your behalf. But again, as I said before, Singapore law generally errs very much on the side of protecting life and preserving life. Okay? So even if you have an appointed decision maker to make medical decisions, right? They still actually cannot refuse treatment which is life-saving or necessary to prevent a serious deterioration, and that would usually include resuscitation. So that's something to know. And also, so for the purposes of community first responders and bystanders, I think it's something less to worry about. I think Dr. Chan had gone through the DNR, but as you know, just to remind you, a DNR is actually a medical decision made by the medical team based on clinical factors and patient wishes. It's not a legal document so again, you watch the TV show and they say, oh, DNR, cannot resuscitate. As far as Singapore is concerned, there's no sort of formal DNR document that you would statutorily recognize as a separate category of advance directive, or is there any specific mechanism for their enforcement in the community or non-physician personnel? So the term is not legal at all. What may be more important in Singapore and also for healthcare professionals really is advanced care planning, which has also been gone through with, which is it's the process of planning for future healthcare options through a series of voluntary, non-legally binding discussions about the future care between an individual, their healthcare providers, and persons close to them. Again, it's more of a medical concept than a legal one, and it's really just a way that you should talk about your future ones with the future with the healthcare professional so that they can be guided when making decisions on your behalf in your best interest if they have to do so in the future. Again, this is really not something a bystander or first responder needs to think about because it's not practical for a community first responder to know or be in a position to know or ascertain what has been previously discussed or what their priorities need to be and what their wishes are. It's a bit different from if you are a sort of long-standing treating doctor who has that kind of information. So now I go into, I think, the bigger part of my talk, which is about being a good Samaritan and what are the legal implications of a bystander providing CPR. So, what is a good Samaritan law? In general, we use the term a good Samaritan as a rescuer who responds in an emergency situation where there's no legal responsibility. So, in that sense, a bystander. This does not really include healthcare professionals who are already like in the hospital because that's your job. So, you're not considered a good Samaritan. So there are these things called Good Samaritan laws, which is liability. Okay, so you can see Good Samaritan law, liability protection. We'll get back to that in a bit. But for now, a Good Samaritan law that we're talking about is one that protects individuals who voluntarily provides reasonable assistance to someone in emergency from legal liability. And the idea really being to encourage bystanders to help without fear. Okay, but it's not a completely unfettered sort of defense. There would still be certain requirements. There would still have to be some level of acting in good faith and with reasonable care. Okay, so in Singapore, we don't actually have any Good Samaritan laws. Okay, so there are some countries with Good Samaritan laws that's listed on the thing. In India, their Good Samaritan law is that they have a version of a Good Samaritan law in their Motor Vehicles Act, which states that a Good Samaritan shall not be liable for any civil or criminal action for any injury or death to a victim of accident involving a motor vehicle where such injury or death results from the Good Samaritan's negligence in acting or failing to act while rendering emergency medical or non-medical care or assistance. So that's just an example. All the different countries, they will have, these are some countries that have some version of it. Maybe it's limited to motor accidents, maybe it's limited to something else. It really depends. So as far as Singapore goes, it was actually asked in Parliament before, sometime back 2012, whether it was time to reconsider the appropriateness of introducing a Good Samaritan law. So this is the response in Parliament. Okay. So essentially, the answer was there is no major liability concerns for Good Samaritans in Singapore. Civil liability will generally not attach to Good Samaritans who acts out of necessity and with the care that can reasonably be expected of a person having his skill and experience. As for criminal liability, this generally requires malign intent and will not attach to a Good Samaritan who acts in good faith. So there has been no reported incidents where members of public refuse to render assistance because of liability concerns. In fact, we often see in the news examples of Singaporeans rendering help to strangers in need. Okay, it therefore remains our assessment there is no need to introduce a Good Samaritan legislation in Singapore. We'll continue to study the experience of other jurisdictions and will review our position if the need arises. So basically, Parliament is saying we don't need Good Samaritan laws because our regular laws already takes into account Good Samaritans and will not expose them to liability. So let's take a look a bit more into that. So they refer to two things in that parliamentary response: criminal liability and civil liability. So just a quick refresher, perhaps to those who know, and something to learn for those who don't know. There's two types of law that we're talking about here. Civil law protects the rights of individuals to take other individuals or legal entities to court to settle a dispute. So this is what we would know sort of colloquially like when you sue someone and you sue them for money, right? So individual versus individual. Criminal law is different in that it's about you committing a crime. So it protects the public by prohibiting certain types of conduct. The state prosecutes an individual for having committed a crime, and then obviously the consequence of this is not it's not compensation, it's not paying money to somebody. It can be paying money, but it will be in the form of a fine. But it can also include jail terms and other things like that. Go through criminal liability first because it's easier and honestly quite simple. So, what are the kinds of crimes that will potentially attach to doing CPR to a bystander. So I think the things people tend to be concerned about is like we were saying, maybe I break a rib and I hurt them. Will they charge me for assault or criminal hurt? So, for instance, I've given some examples of the laws as they are, and you see, actually, most of them require an element of intent, right? The intention has to be that you want to cause hurt, or you intend to cause, or knows himself likely to cause the hurt. So similarly, there's the same for criminal force as well. Intentionally uses force to any person. And then I know another potential concern is that if you do CPR, you might have to, touch a person's chest, and then there's this issue, would they accuse me of molest? So again, outrage or modesty, you do need to intend to outrage, or knowing it likely that they thereby will outrage the modesty of that person. So all that is to say that, of course, if your intention is not to do those bad things, and the intent was clearly to save someone's life, and do your best, there will not be any criminal liability attached to what you have done. And as far as I know, I don't think anyone has been charged with something along these lines in Singapore. So that you have nothing to be afraid of if you act in good faith and with pure intent. So this also not super important, but it's just to say that our laws and criminal laws in this sense takes into account, exceptional situations. So these are some exceptions that maybe you will also fall within. Putting aside, you might not even fulfill the element of intention. There's also other exceptions, which is that if you do something in good faith, or you do something, to try to prevent or avoid harm, which I will suppose doing CPR is. Okay, so the other aspect, which potentially might be a little bit more complicated, is civil liability. Okay, so the civil liability that potentially may attach to doing CPR on someone would be that of a tort, and specifically the tort of negligence, which is a civil wrong that causes a claimant to suffer loss or harm, and that might entitle them to compensation. So I don't want to get into it too much, but I think, listing out the different elements that must be fulfilled gives you a better idea that actually not so easy to sue people. You really have to go through all these things. And in that sense, you don't have to worry too much about it. So the first stage is duty of care, which is really sort of a legal obligation to take reasonable steps to avoid causing foreseeable harm to another person. All that is quite legal to kind of like establish duty of care. But like in a lay person kind of view, it's really quite common sense if you think about it. So for instance, if you drive a car, right? You will have a duty of care to be a sort of reasonable and competent driver and not cause, havoc and harm to other people around you. Or, in the most famous legal case that the thought of negligence comes about is that there was a bottle of ginger beer and there was a decomposing snail found inside. And then somebody drank it and got ill. And the court found that, the people who manufacture these things, they also have to have a duty to ensure that, it is generally safe for consumption, etc., etc. So as far as bystander CPR goes, I think you can assume that if you go ahead to assist someone and you're gonna put your hands on them and do CPR, you do owe, or you do sort of assume a duty of care to do reasonable CPR. So that leads into the next issue, which is that breach. Okay, so once you establish that you have that duty of care, you have to ensure that care that you give is of a reasonable standard expected of a person of his skill and experience. So they will look at the person doing it. So if you're, for instance, a medical professional, you might be held to a slightly higher standard. And I think on the medical professionals in the room, you might have heard before, you will be judged against the practice which is accepted as proper from a responsible body or medical man, Hopefully that sounds a bit familiar, right? So here really is the key point. When people ask me, can you get in trouble if you do CPR? It's hard for me to say definitely not. Because there is still a requirement that you act kind of reasonably.
right? So if you think, for instance, punching someone in the face is part of CPR, then obviously, everyone's gonna be like, no, I don't really think that's right, right? So in that sense, I would say, yeah, you can get into trouble with that. But if you act reasonably as a person of your skill and experience, then you really don't have to worry about it. And that's exactly what Parliament just now was referring to. Liability will generally not attach to good Samaritans who act out of necessity and with the care that can be reasonably expected of a person having his skill and care. The other two is faster and a bit more legal and technical, but we finished all. Okay, causation is just that your negligence or your lapse in care must have caused whatever damage that person is suing you for. Okay, and that also pose. I mean, in a way, it's also difficult for them to bring an action towards you, towards a bystander doing CPR. Why? So I presented sort of two easy scenarios, right? If you do the CPR, person still passes away, what can they sue you for? Unless they are trying to say the CPR caused you to die, which I would say is pretty difficult to establish. So that is, for instance, one hurdle, right? And then scenario two, they do survive, but then you crack all my ribs. But surely your fractures is you're still better off than being dead. Right? So again, they will have to prove that for whatever situation, you would have been better off if you didn't do the CPR, which again, I think that will be extremely difficult to succeed. So I have some questions here that were sort of previously posed to me. So if I didn't receive training for CPR and attempt CPR, I can get sued. So if we look back to what I said before and we think about sort of apply it logically, right? It really depends on the situation as well. If you're in a crowd, there's a lot of people, okay, yeah, maybe it is better to see if there's someone else who is trained in the CPR and let them do it. You can assist in other ways, you can call for help, you can find the AED, right? But what we're talking about a situation where no choice, really no choice, you're all alone, cannot call for help. This is totally emergency situation, right? So as we know from the previous talk, survival is so dependent on quick CPR. So I personally would say bad CPR is still better than no CPR, right? Again, if you don't do anything, the outcome is likely to be death. So that if you even try your best, I cannot see how you would be punished for that, right? But of course, knowing CPR is the best, so we should all get certified for that. So then the second one is if I attend CPR courses and do the steps wrongly, I can get sued. Again, from what I say, it all comes down to reasonableness, right? If there's some minor sort of, if it's not entirely perfect, I think it's fine because I don't think perfection is expected as well. It's the standard is not perfect. The standard is reasonable. So again, if you punch someone in the face, thinking that that's part of CPR, maybe that's not reasonable. But if you're saying that my rhythm not the best or I'm too weak, I cannot go deep far enough, I think if you can explain it, I think that can still be considered reasonable. And then the last one is certification is not really a legal document that says, yeah, you can do CPR, no, you cannot do CPR. That's just a matter of like making sure that you are up to date with how you know how to do it. So that's really more substance over form. So there is this thing called Good Samaritan Initiative, which is a collaboration between the Singapore Heart Foundation and Law Society pro bono services to provide free legal consultations to those facing legal issues arising from resuscitation event. But today I really am not sure if this has been used all that very much, and there's no reports of locally made claims against rescuers, and there's no evidence to support the claim that attempting to save lives incurs any real liability. So to sort of end off in a nice note, actually there's been many, 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 many incidents in Singapore where CPR is provided by bystander. And generally speaking, they've all turned out pretty good, right? So these are just some examples that I've taken, and there's a lot more online, right? And these are all bystanders, and that could also include laypersons or medical professionals who sort of incidentally is there. I think the Yishun MRT one is pretty funny because he was on his way to work and then he did the CPR. Then after that the ambulance came and then he continued to go to work at KTPH, I think. And then he met the ambulance there and then the ambulance guys was like, hi, I didn't know you were a doctor, we could have given you a lift. Also, on that note, right, even when things don't turn out good, actually, if anything, it looks like people are more grateful than angry or looking for someone to blame. So there are all these incidents where the family of somebody who has passed away, they thank the people who tried their best to help, or they even want to try to seek them out, to give, to show their gratefulness and all that, right? I think for the second case, it was the two Samaritans. Was one was a SCDF personnel, and then the other one was a nurse. Just to end off, duty to help. So another aspect of Good Samaritan laws is this idea of duty to help. Most of the time, Good Samaritan laws refers to liability protection, but sometimes they also kind of be conflated with this idea of you must be a Good Samaritan. So in some of these countries, they actually impose a legal duty to help on persons capable to help another person who is in danger. So I think in Germany there was a case where a man collapsed in the bank lobby and then passed away. And several of the customers in the bank actually stepped over him without providing assistance. A few helped, one phone emergency services. And using security footage, the customers who did not act were identified and fined several thousand euros for failing to provide assistance. But the person who called for help was not lah. So that is the idea of what duty to help is. I don't know if it's a good thing or a bad thing, but actually there is no duty to help laws in Singapore. Okay, so technically speaking, if somebody collapses in front of you and you don't do anything, you will not incur legal liability. Okay. But separate to that, right? Separate to legal sort of responsibility, I think we also have to consider we might have an ethical and moral obligation to help, right? With regard to medical professionals, it may be argued that they have this additional medical ethical requirement to go to the aid of someone who can potentially be saved by skills and training they possess. But having said that, and beyond that, even as a sort of lay person or non-medical professional, surely you would also want someone to come to your aid if you need it, or come to the aid of your family members if they need it, and your loved ones too. So obviously, I hope that we don't need a law to force you to, go to the assistance of people. And I think I'm quite encouraged from what I see, which is that I think in general, everyone says Singaporeans very mind your own business, but generally speaking, it looks like people do step up and people do try to help where they can lah. So yeah, that's it from me. Thank you.